Bueno, bueno, oh, prendo la cámara. Bueno,
Morning.
Morning.
Mr. Freehoff, I'm having some difficulty with Zoom on my end. Is it me or is it
I can hear you, Judge.
okay? So I'm just going to run through the calendar really quick. I don't think it's going to take anything a whole lot of time. So my understanding is that first position does not need a hearing on their TRO. If anybody's here on that one, let me know. Okay. Position two, Citibank versus Maria Garcia. Who do I have here on behalf of Citibank?
yes.
Ms. Garcia, are you here? Okay. Is anyone here on behalf of Citibank? So, Ms. Garcia, no one is here on behalf of Citibank, but the hearing just started, and so I'm going to give them a few minutes to see if someone appears, and then we will handle it from there. If you're feel free to mute or turn off your video, but just stay attached to the Zoom, and I'll circle back to you at the end of the hearing. Okay, Ms. Garcia,
Okay.
did you understand? Thank
Mm,
you. Um, Towngate Townhomes versus Quiana Sidnor.
Good morning, Your
Do I
Honor.
have anyone here on behalf?
Yes, can you hear me, Judge?
Good morning, Mr.
Hey,
Stamps.
yes, ma'am.
Yes,
Yes, Your Honor. Brent Stamps for plaintiff.
you're here on behalf of Towngate.
I am Judge. Quick announcement in that yesterday afternoon, we received a counteroffer from the defendant that I relayed to my client in about 7 minutes before the calendar. Um, it is being passed to my client's board, and I have a little more hope. Just the way the language was presented to me on my side, that we may get a little further. So I certainly wanted to bring that to the court's attention. Um, I know the case is not terribly old, and I would, kind of hate for us to move forward seeking the default judgment if my client might be able to, accept this counteroffer that came to it yesterday afternoon. So, like I said, I did want to put that before the
Okay.
court.
Thank you, Mr. Stamps. I'll note that Miss Sidnor is present here today. And it sounds like the parties have been in touch. Mr. Stamps, what is the timetable for your board to consider such an offer? And here's why I'm asking. I don't mind, moving this hearing to another day so that perhaps the parties could then tell me, we don't need this hearing at all, Judge, we got it worked out. If I did that, what would be the timing of that for you?
Judge, I believe we should have something later next week. This client is pretty good about getting me a response. I know we have the holiday Monday, but like I said, I would, today's Thursday, that would give them a week if we're targeting by the end of next week, maybe even sooner.
Okay.
Maybe about
the main
tomorrow.
reason I ask about, well, I would welcome that announcement tomorrow, but I also don't want to have the same conversation in a few days. And so, right. So what I'll do is we will look at, I don't know what my hearing calendar looks like for mid-September, but I know Mr. Freehoff has a date that he's got set aside to have this reset on another calendar. And so what we'll do is re-note it to both of you, and hopefully y'all can reach out and tell me, hey, we have a consent order, we don't need a hearing. And if that's not something that y'all are able to get to, then we will have a hearing on the appropriate day, which I suspect will be sometime maybe the week of the 15th of September, but I can't swear to that. So.
Okay. That is fine with me, Judge. And like I said, I hope I'm optimistically encouraged by the preliminary response I received, that hopefully we can get an acceptance on my side and get this resolved without the default judgment.
Okay. Ms. Sidnor, do you understand and agree with what we're doing, what I've just announced?
Yes, Your Honor. I fully understand. Thank you.
Okay, excellent. Well, thank you both. You're free to log off.
Great. Okay.
And we'll send you a notice of the next hearing.
Thank you, Your Honor.
you.
Your Honor.
Okay, and my understanding is that the C&W contracting case versus AC Property was reset because of an emergency request from Plaintiffs' Counsel. So if anyone's here on that matter, it's going to be reset and you can return a different day.
I'm
Mr.
here.
Wheeler, who are you here on behalf
of? C&W.
On B. Okay, so
I didn't understand
yes,
about the
Mr. Wheeler
reset. What we had submitted our order. Well, the bottom line is it looks as if this case is going to be settled. I'm 99% sure it has in fact settled. But
okay.
we had in our motion and our order, we are not seeking attorney's fees. So my understanding is that we can proceed without this hearing for you to enter a default judgment. Is that not correct?
That is correct.
Okay.
That is absolutely correct, Mr. Wheeler. So if you are, if you want to submit the whatever paperwork that we need to either be in the form of a consent order or to be in the form of a motion for entry of default judgment, which I'm sure we already have. But if it is the amounts are liquidated and you're not seeking attorney's fees, then yes, we can just sign off on that order and enter it. We don't need to reset the hearing.
Okay.
What is the timetable for that to occur? Because here's why. What I don't want to happen is for this to get forgotten. And so what I'd probably do is reset it on our hearing calendar for next week, which is September the 4th, and then just expect that y'all would send me either a consent order or the paperwork, and then we would sign off on that paperwork and remove it from that hearing date.
That would be fine. We did file a motion for default judgment and an order for
right.
Okay, so yes, if you want to do that, and I'm pretty sure that by next week we'll have we can file the definite documents that you need.
Mr. Freehoff?
Judge, It's the Niski Lake matter, which had the emergency request to be reset. This is the matter where Mr. Wheeler has submitted a proposed default order without attorney's fees. We have had no response from the defendant. However, this case will not be ripe to be entered until tomorrow.
Okay. I think I apologize. You had said the notes that we had discussed was that position 4 had a medical emergency, was being excused, and then I think by the time it got generated, 4 wasn't there anymore. So that's entirely my fault. Sorry, Mr. Wheeler, for the confusion. So in any event, yes, the issue was that you don't need to submit anything else, and unless it's resolved and you want to send us a consent order. But yes, the issue is that the last day for the default is today.
Okay.
And so the order that you have submitted, we wouldn't be able to enter until tomorrow. But given that no one has appeared and we've not had any contact from AC Property Owner LP, I would expect that we would put that order on file tomorrow.
Terrific. Thank
Yeah,
you.
I apologize for the confusion, Mr. Wheeler.
Not at all. Thank you, Your Honor.
Thank you.
So I'll be signing off then.
Yes, sir.
All right. Thank you.
Okay, and then do I have anyone here in the co-ed development versus 400 Elm Street matter?
Yes,
Here
Your
you go.
Honor.
Yes, Your Honor.
Okay. So is it Ms. Akpati? You're here on behalf of the co-ed development, the interpleading party?
Yes, Your Honor. As the
Quiet
plaintiff.
title party? Okay.
Yes.
You're right. Yes, ma'am. And then Mr. Whitley, you're here on behalf of Fulton County?
That's correct, Your Honor.
Okay. And Mr. Okorocha, are you here in that matter as well?
Yes, I'm here on behalf of the city of Atlanta.
Okay. What is the status of this case, Ms. Akpati? I know it's a quiet title, and it looked like you had gotten service on almost everyone, and that Mr. Okorocha and Mr. Whitley's clients were the only ones who had filed answers. What is the status of it from your perspective?
The status is that we are in the process of getting the special master. He should have been appointed by now, but we will file that ex parte motion for the special master. And at the same time, we want to go ahead and simultaneously file for an order for publication because all the parties have been served at this point. And what we just will need to do is get the special master. He will file his determination. Most likely, he'll still request for another publication to be done on all the parties. And at that time, we'll be ready to file for default judgment if nobody responds, and then request for the final determination, the final order to be sent to the judge for review and signature.
Okay. That all sounds fine. I think the only concern I have is part of the issue is why has that not happened before now? I'm trying to pull it up right now, but my review of it last night is that a special master had not been appointed or requested, and that the matter had already been at least publicized in terms of service by publication. I typically see those combined, but I mean, this has been pending for 8 months, and so that's a long time for essentially. I mean, if it's a quiet title as to the whole world, then it feels like the special master could have, should have, would have been appointed by now. Anyway, what is your timetable for getting a special master appointed?
He already is aware of the case. I think what happened was there was a mix-up between this because we have 3 cases with the same name. And I think there was a mix-up in it, but I will get that paper out to you today. So the special masters, yes, already
thank you very much.
Yes.
Okay. Well, if you will send us the paperwork to have the special master appointed, we will get them appointed. I don't know what the timetable looks like realistically. If the special master is going to insist on republication, do you have a suggestion? I don't want to put this on a calendar and have you come back in a month. That's not realistic. But it does need to be set down for a final hearing when I expect that all of the publications, et cetera, will have been filed and you can present a final order. When do you think it would be realistic for us to reset that, Ms. Akpati?
I would think like the first week of December. I do expect that you will have the paperwork all before you. I just want to, give some leeway so that to be sure that there's nothing that crops up in between them. But I would think like the first week of December, definitely. Yeah.
Okay. Well, then we will reset this matter for the first week of December.
Thank you.
Yeah, it'll be on a Thursday likely, at a same time as this one, a 9 a.m. setting. I'm gonna assume that this is one of those that, it just sometimes it falls through the cracks. Like you said, it's if you have multiple cases that all have the same name. I understand those things can get clunky, but a year for a quiet title seems excessive. I'm sure that wasn't your preference, but just let's try to avoid that in the future. Okay.
Yes, Your Honor.
Thank you so much. Y'all can be excused unless you need anything else from me on that quiet title.
No, Your Honor, there's nothing else.
No, Your Honor.
Okay. Thank you all. Have a good day. Yes, sir. Okay.
Excuse me, some.
And then that means we are circling back to, yes, Ms. Garcia. Sorry, I had to take care of the rest of the matters to see if anyone was going to appear on behalf of Citibank. Mr. Freehoff, have you looked to see if anyone opened the notice from Citibank? Mr. Whitley, did you need me or are you just waiting to be excused? You're welcome to be excused.
I appreciate that, Your Honor. I thought there was another quiet title matter on the calendar, Monarch Holdings. Has that been reset, or did I have that wrong?
No, it's not on the calendar, but I can't swear to you if it's been reset or if a final order has been entered. Either of those could be true. Mr. Freehoff?
It has been reset. There was a motion to intervene, which needs to be
that's right.
handled. So, so it's going to be reset and a new notice will issue, but a reset date has not yet been determined.
Okay, all right. Well, thank you. I will be happily excused now if that's okay.
Thanks, Mr. Whitley. Have a good
All right,
day.
have a good day, y'all.
And Mr. Freehoff, you were checking the
Yes.
notice to see if anyone. Do we know who the Google Pixel is?
I do not, Judge.
Okay.
Judge, it was not opened by the Lavrar firm. So the filing of the motion is merely coincidental. And also why they would not be familiar with the provisions of our order stating to submit proposed orders and or appear for this matter lest it be dismissed since it's peremptory.
Right. So Ms. Garcia, well, first of all, who is here on the Google Pixel? Is that someone that's waiting for a hearing? I've called all the cases besides Ms. Garcia's.
Excuse me, somebody speak Spanish?
I apologize. Do you not speak Spanish or do you not speak English as your first language?
Speak Spanish is my first language.
Okay. So Ms. Garcia, I apologize. Hello?
Yes.
Yes, I'm on a Pixel.
Can you tell me your name, sir, and what matter you're here about?
My name is Kente Grant. And I had a date for today at 9 o'clock.
Yes. Judge, let me just confirm. I think I know the answer to this, but I'm going to confirm it very quickly. Yes. Judge, this is one where you'll have to explain to Mr. Grant that attorney's fees were not sought, and so the order was granted and the petitioner was excused.
Mr. Grant, I don't know if the order is already on file in your case, but what happened in this matter is that the party suing you was not seeking attorney's fees or any other type of relief. And so an order was presented to the court and it was entered based on the default, based on the lack of an answer. And so you can pursue any appellate remedies that you might want to pursue. There might be legal options that you might have, but for purposes of today, this hearing in your matter was canceled because an order has already been entered on that default judgment.
Okay, so what do I have to do next?
Well, I can't give you legal advice, but we have entered an order that allows them to have a judgment against you in the amount of whatever debt they have that they're recovering from you. And if you, like I said, there is a timeline to appeal that judgment. There are ways that you can try to set aside that judgment. There are things that you can do. I can't give you any legal advice, but there are actions that you can take. You just should be aware that those actions are typically time limited. I would also suggest to you that you should contact the entity that now has that judgment, because oftentimes they will, even when they have a judgment, will still attempt to try and settle the case with the party against whom they have that judgment. So.
Okay, so I need to contact them.
That would be my suggestion, but again, I can't give you legal advice, sir.
Okay, thank you.
Thank you. Have a good day.
Sure.
Ms. Garcia, do you have an email address?
Yeah.
Can you tell me your email address?
It's Chavarria, CHABA Maria, MARIA 386 @gmail.com.
Judge, can I ask for that one more time?
Ms. Garcia, can you say that one more time?
Chavarria, CHABA Maria, MIRIA 386 @gmail.com.
Okay.
I'm going to repeat it because I don't think I got it. I apologize. CHAVARRIA 386.
Chavarria Maria
Chavarria Maria. Okay.
Is that
386.
Ms. Garcia? I heard exactly what you heard, Mr. Freehoff, with the exception that I think she said B, not
Yeah.
V. Ms. Garcia, did you say CHAV or did you say CHAB?
Oh dear, I feel she's frozen.
Mm-hmm. So the reason I asked her for her email address, and you could try either. Ms. Garcia, the email address you gave us, is it CHAV or is it CHAB?
The first one.
V. Okay. But that's what I heard. CHAVARRIA MARIA, and then the numbers that she said.
Yeah.
At what?
Gmail.com.
Yes.
I'm sorry. Okay. The reason I asked for that email is that I think that we could put together a very poorly worded Google Translate email to explain to her that the matter has been dismissed. And that's going to be the best way for us to handle that. Ms. Garcia, this matter, the person suing you did not show up today. And so I'm going to dismiss this matter. We're going to send you an email that confirms that, and this case will be closed and dismissed. I understand you, English is your second language, and if you have someone who can translate for you, you can contact Mr. Freehoff and have him explain it with someone who can help you understand it in Spanish.
Okay.
Judge, I have a
But
quick.
we will send you an email. Yes.
Okay.
I have it called up, the phrase, your case has been dismissed in Spanish. Do you want me to say it or not?
Try.
Okay. Ms.
Yes.
Garcia, su caso ha sido desestimado.
Where is that?
Su caso ha sido desestimado. Okay.
Do you mean like the case has been closed or?
Yes. Sí.
Okay.
Okay.
Okay. Thank you.